This courtroom hearing might look routine at first glance, but watch closely. In just a few minutes, you're going to see how a simple request about an ankle monitor turns into a life-changing decision about trial rights, and later, how a second defendant faces the brutal reality of probation revocation. We've got medical issues clashing with pretrial rules, a 65-year-old defendant under pressure to choose between a jury and a judge, and finally, a woman whose second chance on deferred adjudication is hanging by a thread after a drug violation. Pay attention to how calm the judge sounds, because behind that calm voice are hard deadlines, strict conditions, and consequences that don't care about confusion, family pressure, or addiction. Would you be ready to make these decisions on the spot? Let's break it down.
I'm sorry, Josephine Mariquin.
Judge, we are on the docket today. I will confer with the state in a moment, but I knew you were going to start picking a jury and there was an urgent issue. They've agreed. We've asked you to sign an order that allows pretrial to loosen her leg monitor a bit. Her doctor submitted a letter to pretrial saying that it's causing her swelling and pain. And pretrial told me they would not loosen it without your order. So the state has graciously signed off, and I just wanted to get that done.
Who is the pretrial officer?
Her name is
Valdez.
Priscilla Valdez.
And a judge,
No, talk, just me. I'll talk for it.
All
right, just give me 1 second.
Just,
All right, well, I understand that, but
And you say Valdez?
Valdez. I have her email. If you want me to forward her email to Norma, I can do that, Judge.
Yeah, let me see her email.
Okay.
Do you have any objection to the court sending her email, letting her know that the monitor is to be loosened?
I have no objection.
Okay.
Priscilla, Pri.
Oh, just 1 second. It's probably best that I just see.
Yes, I understand what you're saying.
Hey, no problem.
And I apologize, I left my jacket in the 379th, but when they said you were about to pick a jury, I just ran over here.
Oh, no problem. Okay. Wait a minute.
Not the first time I've had issue with this particular pretrial on a case.
RIS.
And if maybe I'll set the remainder of the bond motion for a hearing because the state couldn't agree to just completely removing it, of course. But I just wanted to make sure it got loosened because she's been in pain for a while.
All right, thank you.
And I'll come back and confirm.
All right, thank you.
Thank you, Judge. You for that. Thank you so much. I'll be back to confirm. I believe today was our plea deadline. We decided the discovery acknowledgement. She's rejected the plea, so we'll need to set it.
This first exchange might seem minor, a leg monitor being loosened because it's causing swelling and pain. But legally, this moment says a lot. Pretrial conditions, like ankle monitors, are not just gadgets. They're court-ordered restraints on someone's freedom. The doctor has already flagged a medical issue. Pretrial won't touch the device without a judge's order, and the state has to sign off. Notice how many layers of approval it takes just to make someone a little more comfortable. The judge is balancing public safety, compliance, and basic human dignity in real time. And did you catch that line? Not the first time I've had issue with this particular job on case. That hints at a history of friction with this pretrial setup. What do you think? Should medical complaints automatically trigger changes to monitoring, or should it always require this much legal back and forth?
All right. So do you want a jury trial or a bench trial? If you come to me for a bench trial, if the state proves its case beyond a reasonable doubt, I'm going to find you guilty. If they don't,
I'm not going for, excuse me, I'm not going for a jury trial. I just need time because I have all my stuff in the storage, Yana, and I haven't taken nothing else because of the monitor, and I understand.
no, so here's the thing. Today is your plea deadline date. So these are your only choices. Either you're entering into an agreement with the state today, or either this is being set for a jury trial or a bench trial. A jury trial, what happens is 12 people sit in the box. The state presents their evidence. Either a jury, if they can come to an agreement, they'll either find you guilty or not guilty, or say we can't reach an agreement. If you decide to do a bench trial, that means that I will hear it or another judge will hear it. The state will again call their witnesses. If I believe their witnesses and find them to be credible, and I believe that they prove their case beyond a reasonable doubt, I'm going to find you guilty. If I don't think they've proven their case beyond a reasonable doubt, I'm going to find you not guilty. So your choices are for today are, do you have an agreement with the state? If
No.
not, then it's either jury trial or bench trial.
I thought I had until January.
No,
No?
no,
Well, I don't know yet. I gotta talk to my son.
no. How old are you?
I'm 65.
All right, don't
Really
put that,
65.
here's the thing, don't put that pressure on your son. It's your choice. So either you're gonna reach an agreement today or either you're going to jury trial.
I guess I'll do the jury trial.
All right, Ms. Ferguson, it appears that this is a case that shouldn't last long. It's a drug case. Excluding jury selection, it'll probably be 2 days. So your plea deadline date has expired. The court will not consider any plea bargain agreements with that good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes, ma'am.
This is where the pressure really hits. The defendant is 65, clearly confused about timing, and thinks she has until January. The judge shuts that down instantly. Today is the plea deadline. No extensions. No, let me think about it for a few weeks. This is a harsh reality of criminal court. Deadlines are firm, and missing them can lock you into much riskier territory. The judge does a good job explaining the difference between a jury trial and a bench trial. But notice how fast the decision has to be made. Agree to the state's plea today or commit to a trial. The defendant even tries to lean on her son for guidance, and the judge pushes back. Don't put that pressure on your son. It's a reminder that, legally, this choice is deeply personal and ultimately hers alone. If you were in her shoes, with a drug case and only 2 days of trial expected, would you gamble on 12 strangers in a jury box or trust a single judge to weigh
What
the
date?
evidence?
All right, your jury trial date is going to be September 9th. Once you sign the reset form, your excuse, just have a seat and your attorney will bring the reset form to you.
Thank you.
Welcome. And counsel, it shows that the recipient read that email, so everything should be fine. You're welcome. You're welcome. You have a subpoena, which you told me you have a subpoena. What's going to end up happening is the state, they can file legal documents to have you attached. What does attachment mean? That means that an officer or some member of law enforcement will go pick you up wherever you may be and bring you in to testify. Do you understand? So they're going to call you, let you know where you need to be and when you need to be for your testimony, and you need to make sure you're here. All right. So do you have any intention of not appearing? All right. Is there any question you have for me about subpoenas and what they mean? All right. So you've been subpoenaed as a witness. That means that you have to appear. That's a legal document, and there are consequences for not appearing when you've received service. Do you understand? All right. Thank you.
Now the judge shifts to something many people underestimate: subpoenas. This isn't just a please show up if you can note, it's a legal command. The judge carefully explains attachment, which is a serious step. If you ignore a subpoena, the state can file legal papers so that law enforcement physically picks you up and brings you to court. That's not drama for TV. That's real procedure. The judge is actually doing this witness a favor by spelling it out. You must appear. There are consequences if you don't, and pretending you didn't understand won't fly later. Think about how many people casually ignore mail or avoid answering calls. In this context, that could end with an officer at your door. Would you have realized that failing to appear as a subpoenaed witness can lead to being forcibly brought to court and possibly facing your own legal trouble?
Good morning.
Good morning.
All right. The court is calling 2017 CR 3456W, State versus Katrina Goodwin. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Todd Conrad, Ms. Goodwin.
And are you Ms. Goodwin?
Yes.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Katrina Goodwin who was placed on deferred adjudication in 2017 CR 3456W for the offense of theft of property less than $200,000 on May 15, 2017 for a period of 5 years and extended for a total of 5 years? Is that you?
Yes, Judge, that was me.
All right, state.
Yes, Judge. State is alleging that violation of condition number 2 on or about the 6th day of January 2025 in Bexar County, Texas, the defendant, Katrina Goodwin, did then and there illegally use a controlled substance, namely amphetamines, in violation of condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
The state will waive and abandon the remaining violation, Your Honor.
No objection, Your Honor.
Just one moment. I'm trying to find the indictment. Here we go. All right, I think the judgment needs to be corrected. We can go off the record. The judgment needs to be corrected. The judgment puts this as a second-degree felony, but she pled to a third-degree felony. So just one moment. This was before my time. All right, Adriana, the judgment on this needs to be changed to reflect that it's a third-degree felony. Here you go. All right, we are back on the record. So you entered a plea of true to violation of condition number 2. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
Yes.
That agreement is to continue probationer on probation, but the state is recommending, in line with the probation's recommendation, a 1-year extension, weekly reporting, and weekly UAs for the first 30 days.
Here, the stakes are even higher. Katrina Goodwin isn't just on regular probation. She's on deferred adjudication for a felony theft case involving property under $200,000. That means the court held off on formally finding her guilty, giving her a chance to avoid a final conviction if she followed the rules. But now, the state alleges that she violated condition number 2 by using amphetamines, and she pleads true. Legally, that's huge. By admitting the violation, she opens the door for the judge to revoke that deferred status, find her guilty, and sentence her up to 10 years in prison and a $10,000 fine. Notice the judge pausing to correct the record from second-degree to third-degree felony. That matters because it controls the punishment range. The lawyers even suggest keeping her on probation with an extra year, stricter reporting, and weekly drug testing, showing they're still trying to salvage her community-based sentence. But remember, the judge is not bound to go along. Once a violation is proven or admitted, the judge holds almost all the cards. Would you have pled true in her position, knowing that kind of prison time was on the table?
All right, thank you.
Yes, Judge.
All right, so Ms. Goodwin, I don't think you're a good candidate for probation. And let me explain to you why. This is not your first time with a motion to revoke. It doesn't appear that there's anything else that can be done to help you. I understand that drug addiction is very difficult to conquer and you have to stay vigilant. But when people give you the tools that you need and you just don't use them, that's a problem. So I don't think you are a good candidate for probation, and I'm not going to continue you on probation. So I'm going to grant the motion, find you guilty, and revoke. Counsel, did you want to speak to years? Because
Yeah.
she's been on probation since 2017.
Correct. She has completed the successfully Take Peach program.
Mhm.
And judge has also done the 90-day jail sanction. So she has some back time.
Mhm.
So we're asking for the minimum 2 years because she was hoping to get, of course, continued with the objective of paying the rest of the restitution. That's why they're asking for extension of a year.
Mhm.
But without that, then we will ask for the minimum 2 years.
And probation, what's the amount of restitution?
Outstanding amount of restitution at this time is $6,977.11.
And who does that restitution go to? All right, the court, as previously stated, is going to grant the motion, revoke, find you guilty, give you credit for any time served, credit for any time in any successful completion of inpatient treatment. There's to be restitution of $6,977.11 to U-Haul. The therapeutic community, the court will sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? And did you sign it?
Yes.
You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. Here's the thing. We can only do so much, right? The therapeutic community is a good program, but you're going to have to request it. I have no jurisdiction to force them to place you in the program. Once you're released from prison, if you can't find a place that can help with your drug addictions, if I'm still here, you can come back here and I'll find a place for you, okay? All right, good luck to you.
Thank you.
You're welcome.
Very huge.
Yes.
This hearing ends on a sobering note. For the first defendant, we saw how something as small as an ankle monitor and a missed plea deadline can shape the entire direction of a case, forcing a 65-year-old woman into a jury trial decision under intense time pressure. For Katrina Goodwin, the stakes were even higher. Deferred adjudication for a felony theft, a confirmed drug violation involving amphetamines, and a judge who ultimately decided she was no longer a good candidate for probation. Despite defense arguments about completed programs, prior jail sanctions, and a push for the minimum 2-year sentence, the court chose 4 years in prison plus nearly $7,000 in restitution to U-Haul. Legally, this is a textbook example of how second chances operate and how they can be lost when conditions are broken. It highlights the tension between rehabilitation and accountability, especially in addiction-related cases.